door. Good afternoon, everybody. I'm Allison Mata, your current host of Defense Diaries, joined with the beautiful, fabulous, intelligent Cara Wieneke.
Hey, everyone.
And Cara, tell them a little bit about yourself.
Oh, gosh. Well, I'm a criminal defense appellate lawyer. I worked on the 2 original actions. I do a lot of public defender work, and I've been following the case since it started trial now. So I think I'm up to speed.
Pretty sure you're up to speed. So, what we're going to do today is I just got a phone call from Bob like minutes ago, and he said what happened in the courtroom. And Karen and I talked about this a little. We were trying to, I was trying to pull up some law here. But so Bob said that apparently there were 3 phone calls from a certain day, and he wasn't sure if it was April at the time, and he didn't have much time to talk. And the state was only playing 2 of them. There was one at 3:13 a.m. that the state was not playing, and then a call at 5:13 and 8:13. That's odd. I don't know if I was taking that down right, but whatever. You get the picture. 2 of the 3 calls that the state was playing. Apparently, the one they're not playing from earlier was, and this is, I believe, is like a summary because this was really quick. Bob had to go, and then I tried to text him afterwards, and it was already green, which means power off. He's back in the courtroom. So these are the calls that Richard Allen was making to his family. So apparently, the call they're not playing was something to the extent of, it's Guantanamo Bay over here, I'm losing my mind, and he's declaring his innocence. And then on the 2 later calls are whatever the confessions were that I don't know and I haven't heard, and Bob has not described to me at all. But at least one of them, and this might be important for our legal analysis, so I'm mentioning, in at least one of them, he says, "Did I call Dad earlier?" And I'm assuming that the call at issue was a call to his dad. So the defense was arguing that they should be allowed to get this in under the completeness doctrine, which is typically when the state or opposing party only puts in a partial statement. They don't put in the entire statement. And you're saying, "Oh, no, I need to get the entire statement in." And their argument was this still goes to the heart of the rule because it shows context for the later statements. The earlier statement call is even referenced in one of the 2 that they are playing. And the judge says, if you want to get it in, call your client to testify. And I don't know if it was which defense attorney, but their argument was, so you're pitting my client's Fifth Amendment right against a rule of evidence. And whatever it was, the judge said no. So I don't know. What are your initial thoughts?
Here's what I bet the judge is thinking is that each call is a separate recorded statement. And so as long as they play the whole call, then it's the doctrine of completeness. I think I would make an argument though. Like, think about it. We saw the interrogation videos, right? How many times did Holman or Mullins or somebody step out, 20, 30 minutes goes by, comes back in again? That's all one big recording. Well, here, Richard's in prison. He doesn't get to just talk as long as he wants to talk. And so he has to make these calls. And, we assume that the second two were made to his wife. And you
One
think,
might have been made to his mother.
okay.
So I don't know if he dialed 3 different phone numbers or 2 different phone numbers and spoke to, 2 people at the same household on one call,
Right.
and then or I think they might all be living together. I don't know. Maybe he dialed the same number and talked to 3 different people.
I mean, you could make an argument. It's all one large conversation. He references this earlier call. I guess I was thinking, do you have to call Richard to get this in? I assume she's saying it's hearsay if you don't. And as the person who's offering the hearsay, you can offer the other party's hearsay. You can't offer your own, right?
Right.
But what about his state of mind? I mean, they're making a huge deal about the fact that he's made these confessions, but if that earlier call would go to his state of mind, I mean, I guess technically she
Well,
can make.
when you look at this rule, I think it does encompass this because it says, I hate the little circles. Oh, they fixed it. Thanks. If a party introduces all or part of a writing or recorded statement, all or part, words matter, guys, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement that in fairness ought to be considered at the same time.
And this would be a recorded statement, I'm pretty sure.
Yeah,
That's
it's
not a
absolutely
question.
recorded.
Yep.
I mean, this
So,
rule is very clear. They specifically, as the way I'm reading this, specifically designate, consider this specific scenario because it says all or part of a recording statement and that you can put any other part or any other writing or recorded statement that in fairness ought to be considered at the same time.
and that is, oftentimes that we see this, at least on the defense side, we see it when, let's say, there's a controlled drug buy and you've got two people talking on a wire on the informant's body or whatever, and you hear the recording, you can hear the defendant talking, but you don't know what he's answering. You don't know what he's responding to. The state's always allowed to get in that informant's comments because they say that's the doctrine of completeness. That's so that you get context. And so that could be the argument, is this first call gives context to the other two.
All right. So
Not without, I don't know what's on them, but
here's the part of the notes. So what we're looking at right now is the Indiana rule, the completeness rule. And in those rules, they've got notes. So this is under the notes and it's talking about cases. So this would specifically deals with different writings or statements offered. Trial court's decision to preclude defendant from introducing recordings of telephone conversations she had with her parents while incarcerated after the state introduced recordings of 3 such conversations was not abuse of discretion. The rule of completeness did not require the admission of the recordings, as the defendant did not testify at trial, and the recording would have been considered inadmissible hearsay. So now I'm going to look at that, obviously, because there's probably a lot in there that will go further, but let's see what else we have. Under the rule of completeness, the trial court is not required to admit the remainder of a statement or portions of that statement if it's neither explanatory nor relevant to the parts already introduced. Under the rule of completeness, admission of the defendant's tape recording and culpatory statement to police officers did not require admission of earlier statement by defendant to police, even though the admitted statement tangentially referenced fact that interviewing officer had spoken with defendant at some earlier time. So that covers us there, where the jury could easily have inferred that references were to the discussion defendant had with officers before the recording was made that day. So why don't you talk a little while I look at this? I'll take this down and I'm just going to read this Hawkins rule and let you kind of go through some more of your thought process on other ways to get around this.
Well, like I said, you could argue that there's a couple things. First, you could start with well, let me say it this way. If they're trying to get it in today and she said no, is there any way to get it in today? I think you try to argue, like you said, under Rule 106, you have to let it in. This is a fairness thing. It was all within just a few hours of each other. The phone call references the earlier call. This goes more to his state of mind. We're not like looking at it in terms of, truthfulness or, he's not saying we don't even know what's on this first call, but you could make some arguments that way. If she says no, then the question will be for the defense, is there a way to get these in when it's our turn without calling Richard? I'm assuming, I don't know, but I don't know if they're going to call Richard or not. If they're going to call Richard,
They wouldn't be having this fight.
Right.
I don't think that they're intending to call him.
I don't think so either. I assume if your trial counsel, I assume you wouldn't call Richard in this case if you didn't have to.
There's a couple things. One, he may not remember everything from then and not be able to give a good explanation of why he said the things that he said or what he was thinking. Like, we don't know. And plus he just might, they might just think that he's, like that the jury is not gonna trust his opinion anyway, like that it's him saying it alone isn't gonna make that much of a difference and there's more harm. So I'm gonna just read this. And the defendants here were Joyce. Joyce argues that the trial court erred when it prohibited her from admitting phone calls. I'll share the screen so that you guys can all read along, including you, Cara. Let me see if I can make it bigger. Yeah. Oops. Is that too big? I can't see your screen.
A little bit, yep.
A little smaller. Okay. Tiny bit smaller. Okay. So Joyce argues that the trial court erred when it prohibited her from admitting phone calls made while in prison when the state had been permitted to admit other phone calls between the defendant and her father and mother. She believes the rule of completeness. The court should have allowed her to provide the phone calls. The doctrine of completeness does not apply. At trial, the state presented 3 phone calls that consisted of phone conversations with her father and mother while she was in jail. The phone calls and questions were all contained on one CD, but the state specifically admitted into evidence only certain conversations. Joyce sought to introduce another conversation contained on one of the CDs entered by the state in an effort to give the jury a more complete picture. Joyce did not testify. The state objected because Joyce wanted to introduce entirely different conversations, and as such, the doctrine would not apply. The trial court sustained the objection. Let me see if the rule is the same here. When a writing or a recorded statement or part thereof is introduced, an adverse party may require at that time or any other writing. It is a little bit different. Hold on, let me look at the rule when it was amended. Where was I?
Yeah, this is a little bit different rule.
Right, which might be a great basis for an argument. So let's just see. Let me look at the language. So the rule now right there says
it's pretty close.
It is, but they specifically did. Okay, at that time, comma. Okay, so they may require the introduction at that time, comma, of any other part, and then they put in dash dash, or any other writing or recorded statement dash dash that in fairness ought to be considered at the same time. And this was amended 2014.
Mm-hmm.
And when was this case? Let me go back to this. 2008. So let me go back.
You'll see, though, there were not exceptions, but there are ways that you can get those in, primarily being context. So explain the omitted portion, or place it in context, or avoid misleading the trier of fact. Or here's a great one: ensure a fair trial and impartial understanding. I mean, a few of those would seem to fit if we think we know what's on that first call, where he's saying Gitmo, I assume he means torture. I don't know what else he would mean by it's Gitmo here.
Right. This is so odd. Have you ever seen, literally, it looks like I'm comparing word for word. The only other change in adverse party.
Oh, you mean between now and then?
Yeah.
Yeah, and I'd have to see.
Is the dash and a comma. But
Here, and we've got, so we actually just got handed down earlier today rules that have been tweaked like that. So our current Supreme Court is trying to tweak a lot of the rules to make them more understandable, I think, or easier to understand. So there must have been some kind of question in this old rule, and they thought adding the dashes, M dashes, whatever they are, I think they probably thought adding those might have made it clear that you get to use other recordings also.
yeah, but this was 2014. I would just want to see when after Joyce, she wrote 6 letters. All right, what about these phone calls? That's what I want to see, is when the phone calls were.
Oh, is it?
I want to see if they were the same day, because it didn't say it in the.
Because if the call is to somebody different than who the other 2 calls were to, well, that would argue against.
So you got February 15th, 20th, and 21st.
Yeah.
Okay, so that's first, but in the let me go back to, I think it was footnote 12, but yeah. All right, so let's go back to. All right, so they said this rule may be used to admit omitted portions of a statement in order to, as Cara was just saying, explain the admitted portion, place the admitted portion in context, which would be one reason here, also explains it. So
Right.
Both of those apply, and avoid misleading the trier of fact, as you just said. It also applies, and ensure a fair trial and impartial and an impartial understanding of the admitted portion. The trial court is not required to admit the remainder of the statement or portions of that statement if they are neither explanatory of nor relevant to the parts already introduced. The doctrine even applies to self-serving hearsay statements.
Mm-hmm.
So we meet every one of these requirements. Let's just see if there's anything else they said that helps us distinguish this. The case did not exclude portions of the admitted conversation, but rather chose not to seek admission of other separate conversation. Joyce argues she was not consistently making statements that could be incriminating. While Joyce recognizes that the statements would be inadmissible hearsay, she argues that the rule should allow her to introduce otherwise inadmissible hearsay to complete the picture. Okay, it's limited to fairness. This allows the trial court to use its discretion whether the evidence should be admitted. In this case, the trial court determined that since Joyce would not be testifying, the conversation would be. The trial court determined that unless Joyce testified, admission of the excluded conversations would be unfair, since the state could not question Joyce as to their contents. What? Fairness did not require the trial court to allow admission of the otherwise inadmissible hearsay, while the doctrine of the completeness does allow for self-serving hearsay. That determination should be left to the trial court's discretion based on the facts and circumstances of this case. So, I mean, that doesn't help us much. I just want to see.
No, if I were an appellate lawyer,
I'd be distinguishing the hell out of this.
Yes, you can distinguish it pretty easily, right? Depending on what's on that first call. I mean, because here we don't have any question that Joyce's mental health at that point in time is in question. That's the entire case on the confessions, is whether or not he was psychotic when he said these things. And
Right.
Certainly, if he's having a perfectly normal conversation with whomever at 3:13 in the morning, that's an odd time to call somebody. And, then 2 hours later, or whenever that next phone call, he's saying things. Yeah. My guess is if the state doesn't want it in, it must not be helpful for them. He must not be sounding rational during that first call either.
Right.
Otherwise, why wouldn't they put it in? It supports their case.
Well, yeah, no, they definitely said, let's see, there's one case that cites this head note, so let's just see what happens. This is I mean, they didn't give any details, and just like you said, this case, there's a lot of things that could, potentially distinguish it from, you know, this is, let's see. Watch, this is a reversal of them saying it was an abuse of discretion. Uh, constituted in yeah, I saw some of this in there too, and they were letting all that go, and in the last case, on your whole, special witness rule, therefore, okay, her attorney did not object. Okay, well, we did. Claimed error, they did. Is not available for appeal. Okay, seeks to avoid the application of the waiver doctrine. Okay.
So they looked at this as fundamental error, totally different standard.
Yeah.
Nearly impossible to overcome. Show that a fundamental error, certainly with jailhouse calls.
Okay, so what Cara, as she's primarily does criminal appeals, so she's talking about the different standards that the courts have when they're considering an appeal, and if if a lawyer fails to object, that's a completely different standard. So that's what Kara's discussing right there, that this case wouldn't necessarily be, well, let's just see what it was reversed for. Is it?
Well, and it's red flagged. Here's why. It's an unpublished.
Oh, so it wasn't reversed. It's just unpublished.
Yeah.
Ah,
So
got
we
it.
wouldn't even be able to cite
Right.
it because I think it's too old. We're allowed to cite unpublished for persuasion, not for precedent, but they have to be after a certain year.
Us too. They just did that.
Yep.
I think our year's
Very confusing.
I think our year might be 2021. I can't remember right now, but
Yeah.
every time I go to use it, I recheck the
You
rule.
have to. Yeah. I just try to avoid the memorandum decisions altogether if I can. Try to cite to something else.
All right. Well, I won't bore everybody here with more legal research, but I think it's an argument, a very strong argument. I think it should have been granted. I think that, like you said, this case, you're dealing with what his mental state was at the time that he made that statement. So now let's think about what you were saying before. Is there a way to get it in under another exception without calling him? So state of mind.
Well, I'd start hearsay. Is it even? I mean, it's hearsay. It's an out of court statement, but we're not trying to prove what he said on that call to his dad or whatever as for the truth of the matter asserted. We're not proving that Westville was Gitmo.
Right.
So, and then then even if it is hearsay, you try to fit it into an exception.
So I think he would be considered unavailable because, I mean, you tell me, because this is my mind thinking. If I'm the defendant, if I have the defendant and his witness had a trial going on and was able to assert his fifth and didn't want to testify, the courts say that witness is unavailable. Can you make that same argument about the defendant himself to have him considered unavailable because he has asserted his right?
Probably not. That they probably wouldn't go for it. But what about, we think there's going to be a mental health expert, right? For the defense. I mean, depending on what he says on this phone call, couldn't you call that person? And
especially if their mental health expert now, if he hasn't already, reviews that as part of what he examined for the purposes of his.
Because foundation has been established because Harshman said, yes, this is one of the calls, I assume. You just don't get to play it.
Right, but if he's allowed to, as an expert, he's allowed to discuss the things he relied on, even if they're not evidence. So we just gotta hope that the defense. I mean, all right, just to shift gears, or I'll mention this now, and we'll come back to it. I don't understand. So after we finish this, we're going to talk about like the judge's rulings in general on various things, and then this whole recalling witnesses again and again, and then putting in new evidence in the middle of trial. So just remind me of that. So we've got ways around hearsay that aren't based on unavailability. So the expert thing is definitely a potential way to get that in. And like you said, it's not going to the truth of the matter asserted.
Right. That's the
And
argument you can make. Yeah.
right, and it goes to his state of mind. Can you get evidence of state of mind in? You should be able to, because they put in his statements only hours later. So didn't that put his state of mind around the time he made those calls at issue?
Right. Yeah. Oh
What do you
no,
think about
absolutely.
that?
Because they're saying these calls, because I assume these two calls that were played had confessions in them, admissions.
I'm assuming that, yeah, that's what they were played
So
for.
to me, it's no different than Dr. Walla saying these admissions. The question is, in what context did he make these admissions? I mean, that's the whole thing. And so if this call puts that into context, it should come in under Rule 106. But even if not,
It's an exception to hearsay, state of mind. It's
yep,
within hours of when he made statements that they put in,
yeah.
and that put his state of mind only hours before at issue.
It's also, if your timing is right, 3:13 in the morning. I mean, who calls somebody at 3:13 in the morning? Oh, maybe there are some people who do, but that would seem unusual. And I'm surprised he was even able to through the prison. Maybe they have, more lax rules than I thought they did. But
Or they're letting him make phone calls left and right, trying if there's something going on in the background where they're prompting him to confess and to call his wife and confess, he may have been given special access to a phone call. That's an interesting question. I'm gonna put it in my
we don't
notes
know the
here.
context around these phone calls.
Right.
These were what do we know when these calls were made? Were they made in April or May?
Bob started to say he thought it was April, but then he was like, "I'm not sure when it was," but he just said it was all the same day, and they were at 3:13 and then 5 AM and then 8 AM.
Here's the crazy thing. As an appellate attorney, I'd look at this though. Like if a trial attorney called me and asked me, like they were upset with something that the judge had done with this. I mean, part of the problem is a lot of this is discretionary. And so the judge has a wide amount of discretion to decide what comes in and what doesn't. And so as an appellate lawyer, you're looking at, okay, well, how would you argue to get it in? But if she says no, is it going to be the whole case? That's the thing. I mean, really, in my opinion, the jury's either going to buy what the defense is telling them, or they're not. And
So, how do your courts deal with on appeal, like the, um, combined errors thing, as far as dealing with something that takes something that's discretionary and you put it in conjunction with everything else, and it turns into maybe not an abuse of discretion, but it's not harmless. It's prejudicial now.
it's something you can do. Have I ever seen it done really successfully on direct appeal? Maybe less than a handful of times. The idea is you put all these little things together and you try to show that all of it combined made a difference. A lot of times though, you try to do that and the appellate court will still break down each issue and look at it.
Right,
So
because I've
it's
seen
hard.
something
Yeah.
I've seen something that's up for consideration in the Illinois Supreme Court. Can you consider something that the court has said is not an error, like it was her discretion, when you're trying to consider what's the name of that argument when you're like
Cumulative error.
cumulative error,
Yeah.
and that if they have already said it's not an error, it used to be that they wouldn't even consider it in the cumulative error, and I think the Supreme Court in Illinois, I'd have to check to see where they came down on that, was let that issue come through, because there is a time where, although it might not be considered an error alone, it's still cumulatively affected his fair trial, his right to a fair trial.
Right.
But let's hope that we don't need to be crafting his appeal arguments right now.
Right. And if it does go to an appeal, if it did have to, the Court of Appeals would have that phone call. Hopefully that was put in as an offer of proof, and they've got it, so they'll be able to look at it and know if there was something that would have been helpful, or that would have put this all into context. So that helps a bit. I still think the defense will, I'm not telling them anything they don't already know. I'm sure
Right.
they've already thought this down on through the line. We have what, 2.5 weeks left, 1.5 weeks left, November 14th or something. Is that right?
I'm not sure. I thought it might be changing. But she did say that it might end sooner.
And well, we'll see. But I was, it seems like the defense is gonna, if the state rests today, the defense, has a nice amount of time to be able to put on their case. So I'm sure that they've already started working on that, figuring out if there's another way to get them in.
Okay, so um and I hope you guys aren't totally bored by us dorking out on the law right now, but this is this is like perfect for Kara and I. So when I was saying to you, if they haven't already had their expert do it, they got to have the expert listen to that now and have that be part of his, analysis, supplemental analysis. I know he didn't put a report in yet anyway, I don't think, if I remember correctly from the pretrial motions, but that got me thinking to them recalling Mullen to the stand. So just in case anyone out there doesn't know what we're talking about, Mullen, who was the lead investigator and now works for the prosecutor's office, he has been called multiple times. One time when he was on the stand to testify about the video from the Hoosier Harvest store, the jury question was, did you investigate how many other Ford, what is it, Focus
Yes.
are
Yep.
in the general area, to which he answered no. And then they recalled him to the stand to just introduce that. So my question to you, Kara, because I'm like, is where are the rules of evidence? Do we not have any that no, it's a discovery violation? That's prejudicial. We don't have time to do our own analysis of how many other cars look like this car that are also there. And it's a two-part question. Second, I have seen them typically, you call a witness, you're done with the witness, you don't get, it's like if you screwed up, oh well, too bad, too sad. And I've seen I can understand when they put on a witness at a completely different time on a completely different subject. It goes right to the judge's scope of their examination. So a whole new scope of an examination. So the second part of this question is that proper to allow a witness, something they haven't produced before, wasn't part of the evidence during discovery, but two, to recall on a very same topic and present new evidence?
Well, on the first part, two things. I wonder if the defense objected or if they may have already
Bob
known
said there
the
was a
answer.
sidebar, so he
Okay.
assumes that they did.
They may have objected, but I don't think it ended up hurting them. In fact, it might have, helped a little bit because it made them look like they were misleading whenever everything did come out, right? But generally, this is what happens. If you come forward at trial, if the state comes forward with a new witness or new evidence or something, then this is your remedy. If you say, hey, I didn't get that discovery. In Indiana, usually the judge has to give you time to investigate it or review it. And how much time you get, I've seen it where if there's a new witness, they'll say, you've got this afternoon after court to depose that person. So it can be very, very narrow window, or they can just continue the whole trial. Now here they couldn't continue the trial,
Right.
but I don't know how many days passed between him looking it up, but it seemed like, my guess is the defense was probably like, all right, if you're going to put this in, we should have the entire report and we're going to be able to ask him these questions. We want him to look up these things too, possibly. So I
So
didn't think it backfired
so
on the
I
defense.
this would be and I guess it didn't, but my mind's still trying to wrap around how they're even allowed to do that. And I understand what you're saying about the continuance, but what about, is it typical to recall a witness on the very same subject? Now I saw someone in the notes say subject to recall, but that's subject to recall on a completely different topic typically. So I've definitely been screwed by, I either messed something up or forgot something, or I gave an example on the live yesterday. I put in a video with a witness, and it was part of a motion in limine. I fought like hell to get it in. I said I want to start at this point, the words that say "Hi, my name is," and the words that end with "Kiss my ass." I'm making this part up, and it's minute 1 to minute 3:13. I put the witness on. I only played for the jury minute 1 to 2:12. So afterwards, I said to the judge, like I said, no, 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 I played till 1:13. They're like, no, you didn't. I was like, or to 3:13, whatever. I'm like, yes, I did. It was the whole point was that last part. Again, subject to motions limit. They wouldn't let me fix it. They wouldn't let me recall the witness. The judge wouldn't let us, would do nothing, even though everybody knew that the whole point of that was to go to minute 3:13. So is it typical to let them recall a witness on the same scope? What cars
I've
drove by?
I've seen it before, and I've seen what Nick is doing also is breaking up the law enforcement testimony, or at least we thought he was going to do it more than he has. Where didn't he call Holman twice or Mullins twice? He's kind of broken it up a little bit to try to limit the cross. I don't know if that's why he's doing it just for that reason, or if he's doing it chronologically. Either way, yeah, I've seen that in cases before. I've seen it much worse. I had a case where they called the same detective 5-6 times in their case in chief.
That's sitting in the courtroom to adjust based on everything happening. It's outrageous.
And you're in general in Indiana that's permitted. But the other thing as to whether or not he gets to be recalled, I guess are you asking, does he get to be recalled by the state, or do you mean by the defense too?
Well, I was saying like the same witness for the same topic by either side, and it sounds to me like you're saying they do that a lot in Indiana.
Yeah.
And
what would limit you from doing that? Did you release the person from the subpoena, or?
I mean, I don't remember that specific scenario, but I've just never, and I don't know if they've been up there saying so and so subject to recall, but so when you're talking about a continuance, I was screaming to Bob, I'm like, how did this medical examiner, who changed his story afterwards to say it could have been a box cutter, the first time he speaks the words, I know I saw Michael's comment that if
yes, I was just going to say that Michael pointed out, because today may come the motion for directed verdict. And the question is, I think people think they're going to make it, and I don't know if they will or not, but let's say they were to say, hey, you didn't prove, I don't know, that the crime happened in Carroll County or whatever venue. The state is allowed to reopen the case, call a witness, establish.
Shut up. Really?
According to Michael, yeah. I rarely see directed verdict motions made, because you don't have to, and yeah, it doesn't.
In Illinois, you have to. And then you have to reassert it at the close of your case to preserve you having made it in the middle.
Thankfully, you don't. The only time in Indiana, you still have a sufficiency argument on appeal, even if you don't. The only time I've ever seen it, I don't even know if I've ever seen it work, quite frankly.
No, because like you said, a sufficiency argument would be.
Yeah. And I have seen cases where they reopen the evidence, and
after the judge hears the motion. And she's like, all right, I'm going to grant it unless you reopen, or she says I'm granting it, and then the state says, well, we moved to reopen. Like which?
Yeah, the state will. The judge will say, state response, and the state wants to reopen the case and fix the error. Yeah, and then
what in the hell?
Yeah, because again, if there's not sufficient evidence, you can always raise that on appeal. But yeah, it's kind of an interesting. Maybe that's just an Indiana thing.
That's what they do. That's crazy. That is crazy. There's just it's like I was talking about it yesterday. It's supposed to be, the law is set up to, like, a tie goes to the runner in baseball. A tie always goes to the defendant. Always goes to the defendant. Evidentiary rules err in favor of the defendant, right?
In criminal cases, it's supposed to, yeah.
Right, in criminal
well,
cases,
I guess even in, you don't have the burden even in civil cases, but
right, but especially in criminal cases. And so anyway, going back to the ME saying changing his story to be a box cutter, not in a report, never heard the words for. So I was saying to Bob, are they not asked? Maybe they already have somebody to address this. I don't know who their experts are, but I'm like, make a motion for a mistrial just for the record, and a continuance, obviously it's just Bob and I like screaming at each other. But
they may not want a mistrial. Because here's the bad thing about a mistrial. You've shown some of your hand already.
Yep.
And I rarely see a state's case that gets worse on mistrial. Usually they figure out what they did wrong and they fix it. And so they may have
get the chance to fix it anyway.
and they may have a forensic pathologist they're going to call. I don't know. I'll be interested to see. As I don't think they necessarily dispute how the girls died. They just may dispute with what.
So now I'm going to go to the judge's evidentiary rulings. This whole A, outside the scope, and B, when you're impeaching the credibility of a witness, that she is calling that, and C, leading questions on cross-examination. What in the hell? Am I crazy? It's like I started to think today, I'm like, the series Your Honor, where he's literally being forced, to let somebody off. I'm like, this is how I feel watching this, because any first year lawyer could tell you, if you call a witness to the stand, their credibility is at issue. So whether he was fired from a job for lying, anything dealing with dishonesty, fraud, stuff like that, that's allowed. Why is she pretending that you can't do that, and that you can't put words in someone's mouth on cross-examination? And let's start with the impeaching the credibility.
That, I think the rulings sound like they're incorrect based on what I've, granted we're hearing it, secondhand, but yeah, I don't see how that is not within the scope. I don't see how that's not proper cross. I can't tell though, are they doing sidebars right after these objections? Because here's my concern is if, let's say, they go to cross and there's an objection is sustained, if no one's saying, hey, here's what I would have asked, and here's the answer that would have been elicited, that may not be reviewable on appeal because they may not know what the answer is. So I think they asked the warden, you got fired, didn't you, or something? And I don't know that he ever answered the question. If he didn't answer the question and nobody put it in, I'm concerned. Now, maybe it's not a big deal, but
it sounds like you would suggest the defense making mini offers of proof on those things if they could remember those objections. And I mean, I'll tell you, I've never done that before. I see your point, and that's why, having an appellate lawyer in your pocket at trial, and I do a lot of appellate law, so I feel like I have that advantage, and I'm always.
And why you don't want to. You don't want to keep going up there, turning on the white noise and talking to the judge. It annoys the jury. You're wasting their time.
But you could do it after the break. You could say, Your Honor, I want to make an offer of proof.
Yeah.
I've had a situation where that has happened, something similar. Yeah. And I've said, I want to make an offer of proof. And the judge says, all right, we're going to do it at some other time in the future. And then trial keeps going. I forgot. She forgot. And then I never got the chance to make my offer of proof. And then I think I tried to do it in a post-trial motion. Like, I asked to make an offer of proof, and you never let me make the offer of proof. And like, you didn't ask again after I told you, sure, I'll let you do it at some other time.
Right.
Because that's your mind on trial. Like, you can't remember every single, thing. And you sort of shrugged when I said, couldn't they ask after the fact? They could make an oral offer of proof that this is what he would have testified to. But you're saying without that witness on the stand, it might not count.
I mean, they can make an oral offer of proof. This is the answer he would give. They could do that. They just have to, I think you'd almost have to ask the court, can we make this offer of proof later? I think if you don't ask and you wait until later, then a court of appeals could say, you've waited too long. That wasn't contemporaneous.
Right, but I did it contemporaneous and then wasn't allowed to correct it post-trial, even before appeal.
Right.
In a post-trial motion.
The way it sounds like it came out, though, in some of these, just the mere asking of the question may be enough for the jury to know, okay. Right. And the objecting may almost make it worse.
Right.
Because they may be thinking he's only objecting because he knows this is a bad fact for him. So
Right.
there's a lot of, it feels like there's a lot of strategy that, it's so hard because we're only hearing, recaps from the people that are in the courtroom. So we have to really rely on them as to what was said. But
I don't know how this Kaylee got a new update. Judges in chambers with both sides viewing the video.
what video is
I
that?
I wonder if she means audio or if they have video recordings while people are on the phones. So
Hmm.
so turning to, so that was impeachment, credibility. Turning to the leading questions, like this, the prosecution saying he's testifying. I mean, we can say whatever the hell we want. The only time I've ever can see an objection is if you're, you've got literally no basis. We're supposed to have a basis in fact, some good faith basis, which you're
Right.
supposed to take when the officer of the court lawyer tells you they have one. Give me my leeway, Your Honor. But a good faith basis to engage in a line of questioning as far as either impeaching their credibility or uh, whatever the case may be. But as far as leading questions, that's what we're supposed to be doing. What is your thoughts on how, like, is this as conspiracy theory as I think it is with her rulings? Could
Well,
she just be like, I'm just some small Hobucktown judge. I don't even know how. I mean, she was up for Supreme Court consideration, right? So,
Well, I'm wondering if we're misunderstanding what's happening, because I kind of wonder if it's more how the questions are being asked. So on cross, I feel like when we do cross, we always end, like we'll say, the van was white, correct? The van was blue, correct? Whatever. We always add correct. Do you agree? Which they're not letting him do. Do you agree? So I'm wondering, a lot of times lawyers will just cut off the question. The van was white, and then wait for a yes and get them in the flow, right?
right,
So I kind of take these objections as trying to break that flow. If they're not making it in the form of a question, I guess technically you could say it's testifying. Most of the time, people let that go. And if they object, it's to break the flow. But apparently, it's not breaking the flow. They've been
so
doing trials forever.
that's
So
a very good point. That without us hearing the whole question, they might just be, like you said, changing their inflection to make it a
right.
question without saying the word correct afterwards.
And she may just be, or I shouldn't say she, I don't know if it was Ms. Diener or not, but they may just be objecting to, like I said, disrupt the
Break the
flow.
flow, right?
And depending on how they ask the question, here's something, like you'll see the judge do something that people think is wrong, and why is this happening? Keep in mind, you don't have a right to a perfect trial, simply a fair one. So there are going to be mistakes. There's a mistake in every trial, because we're human, but
All right.
it's
So then,
when they're patterned that things start to, become cumulative.
so let's go backwards to the one I asked you about before, where she's not allowing them to impeach their credibility and saying that that is outside of the scope. Now, is that Hobunk small town judge? Am I wrong? Is that
No,
just
that's not outside the scope. I think it's credibility is always at issue. Where I think there were some questions that were asked that weren't credibility necessarily, but they might have been judicial efficiency. Let us ask him about these things, even though it technically might be outside the
right?
scope. Um,
But what about the ones where the guy was you got fired for putting lying on an application question? That's
that I would have thought that's in the scope. I mean, credibility is always
right.
in the scope of direct, right? How do we believe anything? And I don't know where they were going with that. Were they going to say that he had falsified that particular letter
I
by
think they were
adding the
just
date?
saying that he got fired for falsifying and, for
Well, you don't know if they were going down that path, which clearly would have been within the scope. If over that letter, but we don't know because they got cut off. So
little Miss Madhead, maybe if I'm saying that right, or Jane. I 100% agree. Come on, guys, if you want these afternoon sessions to keep going, I need your likes. Got to get those thumbs up. So just minimize the chat. Give a quick thumbs up. Share it. Even better yet. Especially we have Cara with us. So let's get this thing out there. But with all these rulings, and you know what? It's not fair to ask you because as a practicing Indiana lawyer, you are not supposed to badmouth a judge. So
Right.
I'm putting this in perspective now. I apologize. I'm not going to ask you any more of those questions. I'll just say what my opinion is. Um, but yeah. Uh, okay. So now what from what you've been seeing, is there anything that like stands out in your mind that you're like, just kinda got you thinking or something you wanna bring up?
I'm kind of interested to see. So we were left with a cliffhanger with Mr. Weber, and didn't they ask him what were you doing the week before? I don't know where they're going with that. So I'm interested to see what that looks like, and I'm interested to see how they've put their case together, even without the third party guilt, which I don't think will come in still. I'm interested to see how what they've put together on their side.
Alright, so I'm gonna comment on the Weber thing, but then I wanna circle back to the opening of the door and get your legal opinion on that. So here's my thought on the Weber thing. 2 things. 1, I don't know, and maybe you do. To me, when they were in doing their mini openings during, voir dire or jury selection, and they said he was going to essay these girls, he was interrupted, so you know, he red rubbed them. I was like, and then he said it again in opening. I was commenting during one of the lives, like, all right, this is now something they've like repeated multiple times. Like he was going to do this, but he was interrupted. So I'm putting us all on, like, put that in the back of your minds, because it sounds like the state's got a plan that they're actually going to put something specific up that interrupted them. But if he came home at 2:25 and the perpetrator was interrupted, how in the hell do you continue for another hour and a half before Sarah Carball sees you at 3:57? It to me, I was like, you know what? Don't even have him coming home later. If he came home at 2:25 and the girls weren't unalived until 3:50, so for him to get up there by 3:57, how is that an interruption?
It's interesting because I don't know if the I was interrupted was in response to the thought that they couldn't find any evidence of sexual assault, or
It was his statement that they played
I should say
yesterday.
SA, sorry.
Yeah.
Yeah, if they were trying to make the evidence fit the statement, or if they were, trying to, I don't know. I mean, that's the thing that's really weird about it, because none of it makes any sense. But I don't know enough about the case before trial started, so I had not heard. I knew Weber lived nearby. I didn't know his role or anything. But some are saying that he actually changed his timeline. He had said before he came back later. Then
Right, and to me, coming back later could have interrupted the perpetrator. But at 2:25, clearly the perpetrator wasn't so worried or interrupted if he didn't leave until 3:57. So if he came home later, the closer he gets to 3:57, in my mind, I'm like, all right, just
then makes me think there's information that he did come home later, and I don't know if
I think Bob said, "Didn't you tell the police that you were out?" So I think it sounds like, I think that's what he said the question was, that he told police that he had stopped and done
made some
these
stops.
these
Yeah.
ATMs. But yeah, so Weber lives on the access road leads to his house, and that would have been on the other side, the opposite side of the creek from where the bodies were. So I don't know, with that being so low, I mean, obviously if he's interrupted where they lay, and that was very low ground. It was a ditch, or, whatever you wanna call it. I don't know if you can see the road from there. I'm not
Well,
sure.
so if he's coming home, let's pretend that he came home at 3:30, 4 o'clock. If he's coming home, would he have seen the girls?
At first, I thought that they would have because I thought that road was much closer because I had
Okay,
a court goer tell me he drove right by there and that road's right up against there. But then when we looked at the map, I said, "Nah, that's too far away." So I wasn't actually sure if especially if they're laying down. Okay, if they're laying down and they're already deceased, I couldn't in good conscience say that I think that the cop that drove up to the Weber's house around 5:30 that evening should have seen the girls there. But if someone is standing up, you know, if they can see him, he can see them, and this is this guy's property. He's going to see somebody he's driving, he's coming, so he's watching for a while, right?
right.
So you would think that yeah, he would have seen them, especially if the person down low, you know, well, I don't know. Yeah, I guess it depends on how far down it is there.
Well,
But
I assume the assumption was so I figured this if we're playing if we're playing defense attorneys here and saying, well, why would they move the timeline up if we're assuming he's not being truthful and he's saying I showed up at 2:30 when actually it's 3:30. Well, if it's 2:30, I figured that was because then that would explain that he was on the side of the creek that he wouldn't have seen uh, Rick and the girls, I suppose. Because from what I understand, Rick claims, oh, I heard the van or a man, got scared, decided I was going to hurry up and kill him, hurry up, cross a busy creek, and, construct this crime scene that nobody can figure out. And then I got to
okay.
walk back.
Well, that's a very true statement because the
Yeah.
the prosecution, and I went over with this again with Bob because I wasn't sure, and I think he like relooked at his notes. The prosecution said the words, he was scared, then they crossed the creek.
Yes.
Then they crossed the creek.
Yes.
So in that scenario, I don't even know if Rick could see the road or not. I'm just not sure. Like it's possible, but I thought the road curved the other way. So I don't know, but I don't
It's
think
weird
yeah.
too because if the girls are still alive, would they have not screamed when they heard somebody?
Well, and that's the other thing. The father's there at 3:11. He's in the area at 3:11. He's out of the car at 3:15. He's walking around. He's screaming their names. If you hear your father call your name now, even if you were not screaming before because of a gun or whatever, you're going to scream. Your daddy's that close by.
Right.
I can't in a million years imagine if you're hearing your dad scream, you don't scream out. But could there be a scenario where the person with the gun hears the dad scream before she hears the dad scream and says, "If you say a word, I'm gonna shoot your friend"? Sure, like, of course, that could be possible. But
I I wonder if they figured so if he actually came home at 3:30, I wonder if it's and I don't want to suggest that like the state is putting on false testimony. I'm saying
sure,
I
'cause
don't
it's
know
just
why they would have called him at all. If it was 3:30 because I don't know, we know he didn't well we think that the murder was on its way to being done at that point, right? They're very particular about a person could do it in an hour, but I don't know if a person could do it in a half hour. I mean, that's pretty tough
right,
to
because
do.
especially since the blood spatter expert is saying Libby had to be moved from one spot to the other, but if you assume all other things have been done except the actual, unaliving,
Right.
maybe you can, but I don't even know why they're putting someone on to say somebody got scared that soon, like, so the plan was I was interrupted on that side of the lake, river, creek, so I crossed. You're not being interrupted anymore. Why wouldn't you finish what you were
Right.
doing?
Right.
So with all the excitement of Bob's phone call um, about what they weren't allowed in, I forgot, even with somebody asking the question, putting up there that they were watching a video, until Sleuthy sent me something that Bob also said there was a video of that they just came forward with of Richard Allen while he's in jail, where because the defense put on evidence that he was a good inmate, that never gave him any trouble, blah blah blah, of him cursing and screaming at the guards. Um, and I let me see what Sleuthy sent, if there's anything else in here.
I assume the defense is planning on putting on videos of him in his psychotic episodes, or I guess I thought those were going to come in through Dr. Walla or somebody else, but I didn't hear about
The
that.
state trying to get it in, I don't think to say he was delusional or mentally unwell at that time, but to show he's got a temper, he's angry, he's yelling. And I don't know, we'll have to hear when Bob gets out what the context was, how that came about. Um, but
And they just came up with this.
right, it was not in discovery. So I guess that
Okay.
that's Kaylee's update about them being.
Do you remember when we had all those pretrial motions and lots of complaints about we're not getting everything? I don't know how many of those were filed. And when you give it to us, you're not giving it to us in any way we can even tell what we have. And there was a lot of frustration. And now it appears that there may have been some truth to that if they're finding new stuff. I mean, yeah, this is a big case. I get it. I figured there'd be some stuff left out, but not from the DOC side. That was 2022 to 2024. That's a really small time period.
I have to admit that I'm a little surprised. Like I still stay somewhat naive, and I kind of thought with the judge sitting through all this, even though most of it was presented to her before, I don't know if it was presented quite to the extent it was now, but just seeing the shortcomings in their evidence and in their case, that she might start to change her mind and give the defense a little more leeway. I'm seeing none of that. I'm seeing her remain as um, handling rulings in the same manner as she was before. So I'm not saying one way or the other.
You could look at that two ways. You could look at it like, the way that a lot of people think she's, seems to be favoring one side. You could look at it like she sees, I mean, I'm not in court, so I can't tell how the jurors are reacting, but she's got front row seat to see how they are. Maybe she thinks that, maybe she sees the weakness of the case, if in fact it's that weak, and she's like, hey, I'm gonna, maybe what we think is a big deal, she may not be thinking is that big of a deal. She sat, I mean, this is like, Fort Wayne's not a small town. It's probably our third, fourth largest town, second largest city. It's a big city. She has sat in front of a lot of horrible cases where people have done horrific things. So it's, I'm not surprised by her being very just, business as usual. This is, she's had a lot of these cases. So I'm sure she has a pretty good feel for how it's going for the state. I don't know if we can read anything into it. I don't see it as she's trying to get them across the finish line. Certainly not. I think, I just think, it's ultimately it's the jury. The jury is going to be the one that's seeing all this. And sometimes these objections, sometimes things that the state's doing, it's going to backfire. It could backfire.
But don't you think that when a judge sustains an objection, that then the jury's left thinking, oh, okay, so the defense was wrong?
Maybe in normal cases, but in this case, I don't know. Because usually in normal cases, I see it where the defense's defense is hold the state to their burden. Just remember, they have the burden. I don't have to prove anything. And then whenever it looks like they don't have their own story, then yeah, I think that can certainly come across like, oh, they must not even be allowed to ask that. Here, I don't know. They've made very clear what their position. And me on the jury, if I were sitting there and I hear like defense say, didn't you get fired for dishonesty or whatever? I don't really care if he says yes or no. I'm already thinking, well, I guess I got fired.
Right, for sure, for sure. I was just taking it like just showing in my mind how wrong she is with her rulings. But I forgot to mention with the van, um, so Bob was on Vinny last night with Barb McDonald, and Barb McDonald said, "It has widely," and this is a paraphrase, so don't hold me to it, but widely discussed in the community that the perpetrator may have been interrupted when Weber came home, and that it was something that the police had been talking about even for years before Richard Allen was arrested. So, that kind of takes the wind out of the sails of that for me, like even if it had any wind, okay? But the jury doesn't know that. The jury
No.
doesn't know that. Like, I would have asked Walla after that state, like on cross, well, you did say that you were following stories about this and you knew about it. So you knew that it had been widely discussed or openly, however you want to phrase it, that that the police and the community speculated that believed that the perpetrator was interrupted when Weber came home. And then it would have had the same effect, like you just said, whether she's like, no, I didn't hear that specifically. Then the jury would be like, oh, so it was out there.
I think though, this whole thing falls apart. Well, I wish I could have seen what Brad looked like testifying, because the descriptions are quite comical. Because it sounded like he was turned away from the jury, which is very unusual. I wonder how they like that. But still, they still got a problem. It doesn't matter if they were like the perpetrator was interrupted or whatever. They still have a great big problem that I thought they were going to answer the state, and that is the phone. Why is the phone not pinging if whether they were interrupted at 2:30, 3:30, whatever? That's a great big problem. And I really think them presenting that evidence first and then the defense getting to plant the seed already from the very beginning. I almost wonder if maybe you should have led with Brad. I don't know. I feel like it's just interesting because by the time we got to Brad, it's like, well, he could be wrong.
Right.
I
agree. I agree. By now, the jury is already kind of got their eyebrows up at the state's entire case, and they should have started with that, given something, because they think the bullet's something, and it was nothing. And they thought all those eyewitnesses were something. They were literally quite the opposite of something. I've got to grab water, so I'm going to ask you to talk about your feelings on the motion. I'm going to be listening while I go on the motion to reopen the proofs to allow Ron Holder, Elvis, and the Odinism stuff.
Yeah. So here's my feeling on that. I think it's done at the right time. I almost was worried that they were filing it too soon, because I was like, maybe you wait till the state is completely done and you put everything together that you can find where you think that the door has been opened, put it all in one, and then just present it. I didn't realize we were this close to done. So it seems like the timing is right. But the question is, so like we talked about before, a lot of times it was being reported in the media that she had excluded this evidence. It could not come in at trial. It's just a motion in limine, which means preliminary, or, it's not a final decision, because things can happen at trial. So they can't mention any of this up to, until they ask to be able to mention it. But it wasn't a permanent exclusion. So what they're doing is they're essentially saying, Your Honor, we think that the state opened the door. And so now we want to be able to put that evidence in. And it wouldn't necessarily be her reconsidering the ruling. It would be her, now that she has the context, now she sees what the state's case is. If she thinks that they've opened the door, or if she thinks now, having seen the evidence, that there is indeed some connection between some of this third-party guilt, which she already knows a little bit about, and the evidence that the jury sees, she could decide to go ahead and let them present a third-party case. I don't think she will. I don't know why I feel that way, but I just don't think she will.
But in your legal opinion, ignoring is there a greater connection from the evidence seen? As far
Yeah,
as opening the door part of it, with them saying providing their opinion as to why sticks were placed where, do you think that opens the door?
I thought that opened the door. I thought the undoing opened the
Mhm.
door. That was probably a bad word to use because I immediately thought, something cult like. And apparently they heard it quite well. I know there was some question if he said that, but he did. And then I kind of thought the change from the serrated to the box cutter, in that when he was describing the wounds to Libby, that's not a normal way that somebody perishes from a knife wound to, usually it's just a straight one or maybe on the side. She had a vertical one that right in the middle. I don't know that that would be a fatal wound necessarily. I don't know, but it's very odd. And so when you started to put those wounds together, if you looked at them almost like they were a picture,
Mhm.
um, and there was Sleuthy and I kind of looked at, did it maybe form a symbol?
I was
And
just gonna ask you, is that what you're getting at, and has the defense ever thrown that out there, that those were supposed to be some sort of intentional design?
not that I'm aware of, I haven't seen any of their stuff, but I know they're thinking about it. I do know that. And when Dr. Core was describing what he thought was serrated, then he started saying he thought it was part of the box cutter. Well, it could have also been, it could look like the wings of the symbol that we found. It could look like there were just a lot of things I think they could argue that should open the door. Again, I don't know, there's some question too. Somebody raised it. Do they want to open the door to bringing in this Odinism, not third party guilt, but the Odinism angle? Do they need to? Do they think that they need to do that? They seem to be in a pretty good position. Yeah, you always want to try to tell the jury what you think happened, but that,
But
will it make it worse? Will they start
and
to think it's just outlandish?
right, with the undoing part, because was Pearl Mutter excluded? Am I accurate that she's been
I
excluded
believe
altogether?
so. Yep, because she's
So
part of the third party.
right, so if you ignore everything else, and just deal with the undoing, okay? The state has put into evidence the perpetrator's state of mind. So to put her on to say, no, that's not why the perpetrator had his own personal reason, something very personal to him, that these are an intentional design. This is placed for a reason that means something personal to the perpetrator. Do you think she would grant just that? And it was in one of the paragraphs, because when I read the motion, I said, I wish they would have made this its own separate paragraph. Like, all right, we just want to address this. We don't have to mention Odin. We don't have to mention Elvis. We don't have to mention Holder. Do you think she would be open to that, or it would be the same mentality for her? And that's a big no.
Probably more open than everything else. But my concern would be, how would they do it? Because I think they've made it clear that they don't think it was just one person. And so it would need to be a group. And I'm afraid if she got up there and said, no, it would be, this person was intentionally trying to, if she were to respond to that, if she were to talk about it like it was just still one person, I think that could almost help the state a little bit. But, that's the hard part. They've got
Or
so many questions right now, the jury, I hope, is having, in terms of how could this possibly be done by one person? That's why that's why I applaud people that do trials, because there are so many, a lot of this stuff is strategic. And so you hit these crossroads, you got to figure out which way you're going to take, which path. And I think they're at that point now. They've asked for the third party guilt to be opened, but if she says no, I don't know that that's going to be I don't know that that's going to hurt the defense. I think they've got other stuff to show why that story isn't, why the state story doesn't fit. But,
Right.
I don't know.
So
I don't
I
know
don't
all they have.
right. And I don't know. So DB asks, what is NM? Is that
Nick McClelland?
okay? His motion was denied. McClelland made Harshman view it over lunch. Who's
That
that?
would be probably the video. I don't remember what Nick's motion was.
I'm
Maybe
assuming
Harshman
this
viewed
I'm
over lunch.
assuming this video about that he's still talking about the new video of Richard Allen in jail yelling at the guards.
He's saying there was a motion, it was denied, made him view it over lunch, brought it up on direct, couldn't get it. Oh, he tried to play the video and the defense objected. Nasty move. Well, I suppose, but it sounds like I don't remember which witness it was where they told him you can't read you can't just ask him what the transcript says. You have to read the transcript, and then they read the transcript and they objected. So I don't know. Maybe that's a tip for tat.
Yeah. Yeah. And if you've got to go, just let us know. And
Oh yeah, I'll be okay a little bit longer. I
okay.
assume there's some questions.
That's what I'm about to go to. All right.
The one that just popped up was a good one. I wondered that myself. I said, why isn't anybody talking about the mind-altering drugs? Has that not?
Yeah, that's the one I was. Yeah.
I'm not hearing that either too much, and I would have thought that was going to be a huge part. Maybe we'll hear about it with the defense's expert.
Yeah, because the defense has an expert, mental health expert of some sort, right? Do you know if it's a psychologist or a psychiatrist?
Her name, she was outed. If it's the same one, didn't Nick put her in an motion? And I don't remember her name. I thought she was a psychiatrist. It was interesting too that if I understand right, Dr. Walla I think she knew that there was forced injection.
Yeah, she said she wasn't tracking the medications he was on.
No, like I said, no wonder there were lawyers sitting in the back. That was a nightmare. If I'm a civil lawyer, I'm like, oh, this is going to cost us because
Right.
You're not tracking because, that, as people know, those drugs aren't, that's a serious thing. If you miss a day,
right. And we didn't hear anything about how it interacts with not tramadol. What was he taking?
Seroquel.
Right. He went in with a prescription for anxiety.
He had Prozac, Seroquel, and Haldol, right? Is what they gave him, I guess.
Right. And he was already on Prozac, and they said they shifted his medication. So I'd be expecting to hear. I mean, I think most people know, and I've heard that there's a psychologist or a therapist or someone on the jury, but that once you start tweaking, you can't just tweak those medications, like that right there or something. And Wendy D, thank you for your super sticker. So I'd be expecting their expert to talk about that as well. And then the interaction of all those drugs together. And then, like you guys are saying, just that what Haldol does to the mind, Crypto tax lawyer Cara, so glad you're here. Thanks for all you do.
Glad I'm here too.
Crankin, original artwork by me, titles Justice for Abby and Libby, all net sales to be split to each's scholarship. This is my way of processing this cluster F. Website TRB. Fully typed out because YouTube blocks it here. Okay, so to be, I don't know what TRB stands for. But if you let someone know them, I guess we can say the words at some point. Thanks again, Wendy. Appreciate it. RM Productions, Cara, Allie, y'all believe this shit. Keep on going. Love you so much. Or love you both. We love you too. All right. So Crypto says, Allie is my kindred spirit. She really still expects the falls of criminal procedure and evidence. Cara, I think you're right about Rosie changing how he asks it and Gull still sustaining. Allie, with you, I'm feeling very tin foil. Yeah. All right. Let's see if we
Uh-oh. We lost Allie.
Sorry,
There we go.
it does it when I hit the mouse a certain way. All right, so here's another question from Travis. In this opinion, did they say error but harmless? A reverse question. I think he's talking about the one we made earlier. Question, do they need to do an offer of proof to preserve this? Do they need to play it as an offer of proof? And I think, Cara, you did say they definitely need to, they don't need to play it, but they need to put it in evidence.
Yeah,
Make
so
it
they
part of
can
the
just
record.
put it in evidence, or they can summarize it, though it's better to just put it in evidence.
Absolutely.
Yep.
Yeah. But they don't, to put it in evidence, they don't have to actually play it, but they take the disc and they literally make it part of the record.
Right.
And then Baby Fishmouth, Andy M. Pro, but there was a ton of local gossip starting right away. At some point, perhaps someone mentioned Weber was a suspect and had a history of detaining young girls and had a white van. And I don't even know about all, I don't even know about all that far of it, but she might know something, out there local.
I would have assumed the people that lived around there might have been some of the first folks they talked to. And did we know whose property the trail cams were on that never got picked up?
No, I'm assuming that they must have been in a different ended up being in a different location, but I don't know.
Wow.
And Colette says, has anyone brought up the beers that he bought and drank that day? Wouldn't that be pretty easy to nail down? I mean, if he did that at his mom's, I mean, it's
Oh, good point.
several years later, so I don't know if they still have receipts from, from back
How
then.
many did they say he drank? 6 or
Yeah, I
something?
thought he said 3 and 3. I don't
3 and
know.
3.
Yeah. And then Michael, I think we already got that yet. Sleuthy telling me to check my email.
Oh.
And I think that's all the questions that we actually have. Let me just make sure I didn't miss anything. Nope.
So if they are in court playing the video, I assume the state's still going. I imagine it'll be another short afternoon. They'll probably rest and then maybe the jury will retire for the day.
Oh, it sounds like what they're saying about that nasty move question, and now I'm looking at another text from Sleuthy, is if I have this right, Sleuthy says, yeah, it was a nasty move. He elicited it from Harshman even when he was already denied and he knew he couldn't unring the bell. So the judge wasn't letting it in, and then he got it in. He elicited it anyway. So the same thing that they did before. I don't know. I thought that the judge might have ruled that the witnesses couldn't say, certain witnesses couldn't say what they believed the bridge guy said, and then they got it in, but I think she ultimately let it in. So it sounds like the judge was not allowing that video in after she looked at it, and then he elicited it anyway. So that's, yeah, definitely a nasty.
Oh, meaning the state pulled a nasty move?
Right.
Oh, I misunderstood and thought it was the defense. Oh.
It's allergy day for me.
Do we know which video this is?
It's the video of Richard Allen in the jail yelling at the guards.
Gotcha. Well, how did he elicit it? He just asked him to describe what was on the video?
I guess something like that. I don't know why she would have allowed him to. No, it was something like, it sounds like there was an objection and it was you couldn't unring the bell because I keep seeing the prosecution ask such leading questions. And I don't know if the defense has decided that that their, strategy is like they don't want to object a lot, so that the state's objections seem so annoying to the, for any number of reasons. That can be a
Or
trial
gosh,
strategy. Right.
sometimes they may be given enough rope to hang themselves. I mean,
Right.
That's going back to, again, we started off, what was the first the phone, and the phone guy has to admit that he was wrong. I mean, that's how we started this case, right? With that piece of evidence pretty much. And they were like, well, I got it wrong. It actually, the battery didn't die and then turn itself back on again. And so we had that, and then we go into the bullet that was a match that wasn't a match. And then we had Holman admit that he lied and said it was a match, which, you know, at this point now, if I'm on the jury, I have to be thinking, do I believe any of these people that the state's calling at this point? So maybe Harshman saying it, I would rather him say it than show it, but they may not, you know, they may not believe it.
Right. And you know, I suspect that there's an actual story behind why it happened, that now the defense might not be able to get in because that evidence didn't really get in.
Right. Right. That's the problem. Yeah.
Yeah. And
there's so many things. I bet this is the thing. You don't want a mistrial at this point, because if you're the state, you probably would have done things differently. You would have reordered your evidence, I think.
yeah, I absolutely agree that in this scenario, it would be just a trial run for the state to get stronger, because.
And I'll be honest, when we first heard about this case, when they first announced, they were very adamant that there was no SA. And this sounds crazy, but at least I took some comfort in knowing that, thinking, okay, well, at least they didn't suffer through that. And now we've got this case where I'm not convinced of that now, because they seem to not be looking for it almost. You know, they had what was in their head as to what happened, or what they think happened because Rick said it, I guess.
So this raises another question, because I don't know, like, you might be watching more, getting your information at different places. But when I asked Bob about the lab tech, who they said it was a DNA's lab tech, I was like, okay, they found every loci, like all his alleles, like 100%, or they're like, we think it was a lab tech and they just said that. Like, and I'm assuming if they didn't clearly establish it to the defense, we would have heard some argument like that. But from what Bob was describing, they didn't really specify whose it was, how they ran it, that it came back his full profile. But maybe that did happen and didn't make his notes.
I can't. So you're talking about the contamination, right?
Right.
I can't remember what triggers that, but I remember we did a CLE with a lab with the state crime lab, actually, and they said they all have their profiles on file for this, and it's not supposed to happen. But I don't know how they know to check unless they can see their own markers. Maybe
right,
because they're like, "Gosh, that looks like me."
So from what I understand, it wasn't even no one else. She was the only actual lab tech, and that they
but it wasn't her.
It wasn't her. It was a male's DNA.
Well, okay.
And they put it into CODIS at first. So I would suspect, before they go as far as run it on CODIS, that they have that's one thing that they cross it against, is the database of law enforcement or people in the lab. Right. So that's what she said, not a lab tech, but people at ISP database. So aren't you going to run it before you go as far and put it into CODIS? And I don't know if anyone else heard anything out there. Right.
Well, here's what I understand about DNA. So the cop brings the evidence to like a person at the lab checks it in, puts it in the locker, and then the analyst will actually come get it. But used to be for DNA, they had two analysts. You'd have a serologist, and then you'd have a DNA expert. So they do their serology.
Two different people do it, right.
So, but if she says she's the only person, I don't know where the male DNA came in. Who maybe her supervisor touched it? Right. I don't know how you contaminate.
It just didn't sound like the evidence offered at trial established, yes, it was Tim Jones, and we found his entire profile was there. So there's no doubt, I didn't hear anything like that. But I would assume if there wasn't something like that, the defense would have been putting that out there. Like, which person, how many markers did you find? All of that. But
then again, it causes another problem, because now you've got, okay, that's contaminated. So they found some where there were partial profiles, but not sufficient to do analysis. And I'm thinking, You know, that could be anybody. It could be a lab person. Who knows? You know, when there's one thing contaminated, you start to wonder if there, you know, what else is wrong at the lab. It certainly questions a little bit if everything
Right.
was
And
handled.
DB is saying it's not a male, but I'm fairly certain from the notes that I got from Bob that at least his understanding was that was the unknown male DNA that they put through CODIS. But um,
I thought that they said it. Maybe Andrea or somebody I thought said they said it was a DNA lab tech, that they finally figured out that's who it was, but I don't know for sure. But you know, there's this question. Maybe DB is referring to this because several years ago, none of us knew this here locally. The state police told Russ McQuaid of local Fox 59 that it was a state trooper, I believe.
right,
There
and
was a
that's where I
question
think
about
that
that.
that other part came in that Brandon was saying, and thanks for the sticker
Oh,
there. That and I did hear that as well, but I can't remember. I can't be 100%
oh gosh. Uh,
sure, but
she says cops are counted as, or sorry, Brandon. He says cops are counted as lab employees, and they match the mail data to the cop.
right,
Uh,
but that wouldn't be in CODIS. That would be in a separate, you know, database of law enforcement.
but if a
CODIS,
cop is a lab employee, then both the evidence and Russ McQuaid could be right. It was a state trooper, and I would think it would be the state trooper that brought the evidence to
right,
the lab, which, you know, now I'm having Detective Mark Furman, you know, did he tinker with it before it got there?
right,
I'm
right.
having those
And
flashbacks.
did they really? It's just strange to me that they didn't specifically say in court, unless it was just something they did specifically demonstrate, and no one was focused on that because it was kind of established outright, like, yes, it was this guy. Yes, all his markers. We were 100%. I just would think before you resort to checking CODIS, you would have checked the
Right,
law enforcement and lab people. But
right.
um, in crypto tax, it said the same thing. Thanks, crypto. Lab tech also includes law enforcement.
I didn't know that they were also included. That's even that's even more suspicious.
And when he says per Andrea, I'm assuming he means that was the testimony that Andrea wrote down in her notes, that when she the witness who said a lab tech, that she was including law enforcement. Um,
I
yeah,
would think if it was somebody important, we would know about it, but like somebody pivotal to the case, hopefully we
right.
would know.
That's true.
I don't know though. And I can't remember what it was, which particular specimen, like which piece
Yeah,
of
as we
evidence it
as we
was.
sit here, I can't recall either.
Mm.
All right, well, that wraps this up, guys, and hopefully you've got some fun trick or treating plans. I still have to go get candy.
Oh,
Scarlett texts me. She's like, "We don't have candy," and I was like, "Oh my god, I'm failing. I
good
am
luck finding
failing."
some.
Right? But I greatly appreciate you coming on with us. This was great, and the reason, just so you guys all know, we're not discussing what was actually played and said in court today as far as the what calls they played, what confessions they put forward. That Bob's gonna have to describe those to you directly with a little background, with a sense of tone and tenor. He said he's getting all of his notes, and then he was going over, like, during the lunch break, he was going over his notes to add to it while his memory was still there. He says he's got all of it. He's got every word, and he'll give it to you guys on this evening's live. Thanks,
Great,
Cara. I appreciate it. Thanks,
great.
everybody.
Have a great day.
You too. Oh, wait, we got one more. One more.
Oh,
Uh, Daniel Gorbea. Thank you for that. My mind keeps lingering back to the hair with the skin tag and Libby's hands. Your thoughts on this, ladies?
that's not the hair that was the female family member, or no?
I think it was. I thought that there was still an unknown sample. Bob said he thought not. I still think there's unknown. I just can't remember. Is it from the
I
hair?
thought Dr. Core said hairs, like more than one. And so that's why I thought there was, but I never heard any follow up on the additional hairs. The skin tag, that should have been DNA, right? Maybe
Yeah,
should
it
have been
should have
DNA
been.
in there.
Yeah.
That's weird. I don't know. I don't know how you get a skin tag on a hair.
Yeah. We don't know. We don't know. But I also wanted to thank Susan Waller on Venmo. She sent, oh, sorry, I should have said Susan W. for her $20. And uh, I saw someone else today. There was a Peggy or Ann P. Thank you very much. Appreciate it. Um, and Jessica H. And this was from, I think, yesterday, but she sent $20. This is for it's your favorite time. It's my favorite time during the live. I've been waiting for months to hear one of those. Bob does that in the podcast before he breaks down the law for people. So a lot of people were talking about that. And then I got another from Susan W., another $15 from yesterday. Um, Thank you very much. And a Carrie W. Also, thanks for all the tireless Delphi coverage. I think that was yesterday as well. So, and if we forgot anybody and there's some PayPals, Bob we'll talk about that on this evening's live. Thank you again, guys, for coming. If you haven't liked, I'm about to check.
Oh.
If you haven't already given the thumbs up, do it now. Let us know that you're liking these afternoon sessions so we can keep bringing them to you. And we've got 869. Come on, people. Give us the love on the way out. Let's get those numbers up. Share and like, and don't forget to subscribe. So time is fluid, and a lot of times it's last minute. Thanks again, Cara. And there you go. Follow
Thanks for
Cara
having
on
me.
X, and talk to you guys later. Thanks again, Karen.